They've got dirt at 64 and
We ready?
49 built
Yeah.
the building.
I think that RNA bought that building we're in, and we're a tenant of it.
Mr. Brevard,
Because
uh,
we just renewed the lease.
we're rolling.
You guys ready?
Yes, sir.
I call this meeting to order. Can everyone hear me? Okay. City staff will now call the roll.
Stephen Dinger,
Here,
Jason Trimble,
Here.
Brent Brevard,
Here.
Tim Hunt.
Here. Thank you. Mrs. Early will now announce the board's policies and procedures.
Thank you, Mr. Chair. For the record, my name is April Early. I serve as the legal counsel today for the Zoning Board of Adjustments. I do not represent the city nor the other party in this matter. I am only here to advise this board on its authority and its role and procedure in this meeting and its obligations under Texas law. This is a special meeting called for a single purpose, that is to decide whether the board has jurisdiction and authority to hear this appeal. Today, the board will hold a hearing to review the application, the reports, accept presentations, and deliberate on this matter. However, the board is not deciding the merits of the underlying zoning matter today, meaning that there will be no vote conducted today. Before the board begins, I do want to clarify how this meeting will run so that I can inform everyone of the format, the timelines for this meeting. These rules will apply equally to both sides. The order of proceedings are as follows. First, each side will have 45 minutes for its main presentation. Second, each side will have 15 minutes for rebuttal. Third, members of the public who wish to speak will each be given 3 minutes. If there are citizens who wish to speak, we do ask that you fill out a speaker card. It's not a requirement. It does help this process flow a little bit better and in a more organized manner. And fourth, the board will have time to deliberate and ask questions. The board will only consider information presented today, but again, no decision on jurisdiction will be made today. Finally, our timekeeper will keep the clock and signal the time. It will be on the screen. When your time is running short, council, you will receive a 5-minute warning. Other speakers will receive a 1-minute warning. When your time is up, please conclude your sentence. We will hold all parties to these limits. One more ground rule that I think is very important. Each side should only speak during their time that they have been allotted. While one side is presenting, the other side should not interrupt, object, or speak. You will have an opportunity to say everything that you need during your allotted time for your main presentation, as well as during your opportunity for rebuttal. I do ask that both counsel extend this professional courtesy to one another. Also note that objections from the floor will not be allowed or entertained, as this is not a court of law. You will be asked to remain silent and speak only during your allotted time. Mr. Chair, sorry.
Thank you. Today, we have a hearing regarding B26-010, applicant Barrio Resources, LLC. We will now hear the main presentations. Each side has 45 minutes. City, you may begin. Your 45 minutes starts now. Who will do the warning for the time?
Say that again.
Who's going to do the warning?
Right now.
Okay, thank you.
Good morning, board members. Kyle Kingma, Planning Director for the City of Tyler. The item today is, like you mentioned, an appeal. The applicant is requesting or is appealing the Planning Director's determination made under Section 10-6 of the Tyler Code of Ordinances that digital asset or cryptocurrency mining is an unlisted use and the classification of such use as being permissible in the M1 zoning district only with a special use permit. The purpose of today's meeting, like was mentioned, is to review the jurisdiction on this appeal item. As you see here, this is the subject property for the appellant. This is on 1105 and 1101 West Irwin Street. As you see here on the zoning map, it is zoned M1 Light Industrial. This map shows the adjoining property owners within 200 feet. Public notice was provided in accordance with the ordinance and statute for parties that were, had an interest in this, including the property owners within 200 feet. The authority of the ZBA is to consider appeals of decisions made by an administrative official is established in the Texas Local Government Code, Section 211.009, and Tyler UDC, Section 10-771. While the board is authorized in 211.009, Section 211.010 establishes statutory prerequisites for an appeal to the board, which are that they must be filed by a person aggrieved by the decision and not more than 20 days from the date of the decision. The purpose of today's meeting is to review whether the board has jurisdiction to decide the appeal item given the prerequisites under state law. Only the board can make this determination. The timeline I'm about to show, while it does not include each and every interaction with staff, every application made by the applicant, or every public process that they've gone through for public hearing, it does exhibit the basis of what is before the board this morning, which again is to review whether the board has jurisdiction to decide the appeal given the prerequisites under state law. On May 29th, 2025, Exicor, in coordination with the appellant, Barrio Resources, proposed using the property as a Bitcoin mining operation that houses specialized computing equipment to perform continuous, high-intensity data processing tasks. On July 27th, 2025, in my performance as duty as the planning director under Section 10-6, I determined that the proposed use is unlisted within the Tyler UDC, and that it requires a special use permit in the M1 zoning district to operate. After issuance of the formal classification decision by myself, the owner had a 20-day deadline under state law to appeal that decision if they elected to do so. On July 16th, 2026, the appellant filed an appeal of that decision from June 27th, 2025. And this was done 384 days after the decision was made, or 364 days after the deadline established under state law. It's for this reason that the staff recommends the board dismiss this appeal on the basis that it is untimely under state law. Do you have any other?
Can I ask questions now? On this July 16, 2026 appeal, was that made to this board, or was that the one to the planning and zoning? Or was that an appeal?
It was an appeal filed by the owner. They filed two appeals. One was to the special use permit application that they filed back in May. That appeal would go to the city council based off the special use permit. The appeal that's before us today is the determination made back on June 25th, 2025, or 27th, 2025. That is the appeal of the administrative decision that I made.
Kyle, when you notified the applicant of your decision, how was that notification delivered, and what qualifies as being proper notice?
The decision was notified to the individual that I was interacting with, which was Exicor. They were in coordination with the owner. They provided evidence or provided documentation from the owner that was supplied by the owner regarding the decision that we were discussing. And so I emailed that representative. That same day, the owner acknowledged in an email, not to myself, but to a general staff email, that they were aware of the requirement, and so for that reason, they did have notice of the decision that was made. They were in close contact with throughout that process, through the other party.
So it was the person that you had been coordinating with the entire time, or the individual?
It was with the individual I was coordinating with on this question, who was also coordinating with the owner.
Okay.
So that would be the reference tenant then that you were
The
speaking
tenant,
with?
yes. Exicor was the, I believe, prospective tenant. I'm not sure if they actually had a lease or not. But they were the ones that came in for a pre-development meeting, May 1st, 2025. And throughout that month, there were discussions about the use that was proposed as being unlisted and that it needed classification. On May 29th, the Exicor, who I was interacting with, they supplied information to myself, to staff, that was supplied by the owner to help support the classification, that discussion. And so that was the interaction with the tenant, but it was done in coordination with the owner.
Is the 20-day deadline, is that jurisdictional or is that procedural?
It's jurisdictional.
So going with the UDC, doing an additional 10 days, the city allows, doesn't invalidate anything as well by changing the 20-day to a 30-day, or extending it, I guess?
Yes, Steve Keene with the Tyler City Attorney's Office. Yes, neither party has the authority to change state law, so it is 20 days. At the time that the original 30 days was adopted, that was prior to the amendment in 2019 by the Texas legislature. Prior to that, the statute read that it would just need to be appealed within a reasonable time. So you would follow common law in that realm. But in this case, in 2019, the Texas legislature provided a specific 20-day appeal deadline, and that's the one that we're following.
And there's no alternative wording in the UDC to that effect?
The prerequisite for an appeal to the board is under section 10-211.010, which is the statutory requirement or prerequisite, which is 20 days, so no.
Which is from the Texas law.
Correct.
And Kyle is correct. The state law deadline is 20 days. The current wording in the UDC says 30 days, but we can't go beyond the 20 days. So the appeal deadline would have been 20 days under the state law. Either way, 20 days, 30 days, that's the city's position that they missed the deadline for appeal.
Thank you.
Was there another form of notification besides this email? Was this email the only notification they got? Was there like a formal letter or a letterhead or anything?
The notification was the email that was specific to what decision was being made under what authority. There was no other form of communication.
Right. There were a couple of emails after that that we were shown, but not presented today. Is it okay to talk about those?
It's in your board
Ms.
packet,
Hurley?
yes.
Okay. I'll make sure I get this in order. Yeah, so on June the 27th, also on June the 27th, not long after you sent that email, you got a reply from Mr. Penny asking some questions. And then on July the 23rd, about a month later, almost a month later, there was an email sent to Mr. Penny. I guess I'm pronouncing that correctly. From Marina Lopez. And it says, "Thank you for confirming the intended future use of the properties listed below. Current zoning classification is designated M1. The data processing center is a permitted use under this zoning, and therefore a special use permit is not required." But that contradicts the letter that, your decision, is that correct?
That indicates that the interaction with the permit tech was, would not characterize it as a reclassification or removal of the planning director, the authorized individual, myself, regarding the classification of the property. It was a communication regarding the, what the UDC lists for M1. And so the response, the interaction, if there was a question about the interpretation of the UDC, of my decision, for that to have any weight, that interaction would have had to been with me to discuss the matter. And so yes, there was that follow-up email about what the UDC has listed for data processing service. It was not a confirmation or a rescinding of the determination that I made.
But it's contradictory, though. I mean, you said one thing and she's saying another, but you outrank her. So obviously your word prevails, I suppose.
Does the appearance of conflicting answers affect the appeal clock?
It's the city's position that no, it does not affect it, because, and you'll see arguments later on about estoppel, and estoppel is a doctrine, it's set forth in state law, but it's set forth in my brief filed with the board. City's position, a zoning board of adjustment cannot obtain jurisdiction by estoppel. It's mandatory, it's jurisdictional. That appeal deadline is set by state law. City can't change it. The applicant can't change that.
And related to that jurisdictional question then, and not estoppel, so back to the earlier question, does the form of notification and the recipient of the notification, help me understand the requirements around that for it to be the notification necessary to meet the statute?
The statute does not set out specifically what that notification is, but the way the clock set forth, the timeline running in the Texas Local Government Code, it's from the date of decision. So the city's position is at the time the applicant knew of the planning director's interpretation, which was as early as 2025, that the clock started running from that moment and has been running since that time, since June 27th, 2025. And ran until the appeal of July 16th as set forth on the cause chart.
364 days. So, but as far as the manner or method of delivery then, according to statute, that was satisfied fully?
The city's position is yes, it was.
Even though-
And that any detrimental reliance or differing emails or alleged differing emails, that does not change the jurisdictional requirement in state law, which is mandatory.
Okay.
Otherwise, as Kyle pointed out, there are two requirements here for the board to exercise jurisdiction. Number one, it's an appeal of an administrative decision. That obviously has been made. That's 211.009. But you have to read that in conjunction with 2010, 211.010B, which is the 20-day clock. They're inseparable. They have to be read together. Otherwise, the board doesn't obtain jurisdiction. You have no legal authority to even hear the appeal without meeting those jurisdictional, as Kyle referred to them, they're prerequisites to your jurisdiction.
As far as I know, we've never decided what to hear and what not to hear. So this is kind of an unusual case, and the notion of obtaining jurisdiction as a verb that somebody can do is unusual to me. Could you explain that concept a little bit, please? About
Yes.
obtaining jurisdiction.
Obtaining jurisdiction, jurisdiction is the legal authority for a court or a quasi-judicial board such as this to actually hear a case or a matter before you and act on it. Case law is clear, you're quasi-judicial, so your power is statutory. It comes from the Texas legislature. There, as you already know, there are different areas where you can, you have authority to act. One is with variances, which you do all the time. Today's case, as stated, is a little unusual. It's an appeal of an administrative decision by an administrative official who's authorized to enforce the zoning ordinance, and that's another one. A third type is special exceptions, which I don't think we've ever handled before. So those are the types of authority that the board has to do those kinds. Typically, jurisdiction's not an issue because the appeal was timely filed. And so y'all hear variances all the time. In this case, though, that's what the city is arguing. In this case, the appeal deadline was not met, and therefore the board has no jurisdiction to hear the appeal.
Is that really the only difference between this case and other cases that we hear, is the 30-day deadline wasn't met? Because everybody that comes here is here because they disagree with the decision that planning and zoning has made.
So a variance is a request to modify a specific requirement for that specific property. There's not a deadline to file a variance request. So to your point, yes, it is different in that respect, that there is a deadline to file an appeal. There's not a deadline to file a variance, which are two separate relief or remedies under the state law.
Okay. Thank you. I think I have one more question. And again, it's in an email from Mr. Penny. And it's in the information that we were given. And it just says it's two PSD submissions, and it says, I'm just gonna paraphrase, I'm not gonna read all of it. It is my understanding that the city is now requiring a special use permit for use intended as a data center. I spoke with Marina today, and she informed me that the reason for the change were due to updates in the UDC guidelines. I couldn't find where there was a change. What changes were there? Is that a correct statement, that there were changes to the UDC? Or?
That's incorrect.
Okay.
There was no changes to the UDC. Might be a misunderstanding or mischaracterization of what decision was made, which was a administrative decision.
Okay. Anybody else have any questions? Is that it for your presentation? Thank you. Thank you. We will now hear from Barry O. You have 45 minutes beginning now, and since you, please state your name and address, but I guess it could be your work address. Would be fine.
Good morning, members of the board. Jason Mazingo, my work address is 118 West Houston Street here in Tyler. Number one, I appreciate the indulgence of giving us all 45 minutes. Like Mr. King and Mr. Kingma, I don't intend to use 45 of your minutes, though. We submitted a brief last night, my colleague, Mr. Abel, did, and that brief, I think, well states out our position. It's obvious that you have all read those briefs, so I don't intend to belabor what's in them. I assume that you've read them and I can answer whatever questions you have about them, but I do want to hit a couple high points. One is, you've seen a timeline that Mr. Kingma put up here for you, but there's actually a much more robust timeline that I've got that I can provide to you. Can I approach? May I approach you guys? Sure. Yeah, sure. So,
Are we going to be able to display this so everyone can see?
I can't.
Probably not.
No? Okay.
We have a poster available we could get if the board would like for us to display a poster.
Okay, the one back over.
Pass them back,
The
Jason.
one back.
Just want to make sure the other side has a copy.
Do y'all want us to grab our poster so we can display it, or is
I
it
think it'd
okay?
be good if everyone got to see.
We'll grab it, and bring it back.
Okay, thanks.
And we can discuss a couple other issues before we get to the timeline anyway. Obviously, we're asking the board to deny what's essentially the city's motion to dismiss our appeal. The city's framing is very simple, but it misses some steps. The first thing I would say is that the question here, the only question, is whether you have jurisdiction to hear this case, not whether a deadline has been met. We do not agree that the deadline is jurisdictional. Do not agree with that at all. Jurisdiction is a grant of power to you, and you get that power from the local government code, section 211, that's been cited already. A filing date does not ungrant the power that you've been given. You've been given the power to decide these matters, and missing or making a deadline does not remove that power from you. So this is not really about jurisdiction at all. It's about whether the deadline was met. And that's a merits question, not a jurisdictional question. So we're just asking you to decide this case at the merits level. The court or the board might very well agree with the city on the deadline issue, but you can do that at the merits stage. You don't have to do that at the jurisdiction stage. You can still hear the appeal. Section 211 gives you the power to hear the appeal. The city has not shown that you lack the power. It has argued that Barrio is late. And those are different questions, and only you guys can resolve those questions. Now, there's been discussion about what the actual deadline is. And until 10 minutes ago, I was under the impression that the deadline was 30 days. And then Mr. King got up here and told you the deadline might only be 20 days. And I'll tell you, on the deadline situation, it's chaos. And there's a couple reasons for that. They cited, and you guys talked about variances. This is not the same statute as the variance. So we're talking about classification in 10-6A, which gives Mr. Kingma the power to make classifications, and 10-6B gives us the ability to appeal those determinations. And that's what we're here about. Now, what's interesting is 10-6.B says at the very end, the decision of the planning director concerning the appropriate district for an unlisted use may be appealed to you guys, the Zoning Board of Adjustment, pursuant to Article 8, Division F. Well, Article 8, Division F is about variances. That's not what this case is about. And what's interesting about Article 8, Division F is it has no deadline for an appeal. So the statute that we're proceeding under, the UDC provision that we're proceeding under, does not contain a deadline for an appeal. So we have the UDC saying there's no deadline. We have state law saying there's a 20-day deadline. We have another provision of the UDC saying the deadline might be 30 days, and we have Mr. King now saying the deadline might be 20 days. What I submit is that an individual who wants to invest $1 million in our community should not have to hire a lawyer to interpret the UDC to figure out when his deadlines are or not going to run. And right now, we don't have any ideas, we sit here right now, what the deadline actually is. Because Mr. King just said state law governs this, and that's 20 days. The reason he said that is because if the deadline can be changed, then it's not jurisdictional. It's procedural only. And that's what we submit to you, that it is procedural. It is procedural, and that it's evidenced by the fact that they have changed, the deadline. Now, the city drafted this code. The city chose the cross-reference. If the city meant Division G, which is where the actual 30-day deadline comes from, the city could have written Division G. A landowner who reads the ordinance ought to be able to rely on what it says and follow it to where it points. And we did that, and there is no deadline in Division F. So we shouldn't lose our appeal because we looked at the UDC. Now, I'm assuming they're going to tell you that that's just some sort of error in the UDC, and it might very well be, but it's on the council and the city to correct that, not on my client to divine what their correction might eventually be. There is no deadline under the provision that we are talking about here today. Now, even if there is a deadline, then we don't believe that deadline is jurisdictional. And our brief has pointed you to a case, Dubai Petroleum versus Katz, and I know that you guys didn't sign up to be lawyers, and you didn't sign up to want to read, briefs and cases and all that, but the Dubai case is pretty clearly on point, and it says that a deadline like this is not, in fact, jurisdictional. The city, and Mr. Keene said it a while ago, says that jurisdiction cannot be conferred by consent or by waiver. We agree with that. And we're not asking you to make that determination that somehow you have jurisdiction because of consent or waiver or some kind of conference. We're saying that Dubai's holding, the actual law that comes out of Dubai, is that deadlines like this are not jurisdictional in the first place. It's not a jurisdictional deadline. You do have jurisdiction to hear this appeal as it applies to this particular case. Now, there's a follow-up to Dubai that comes exactly in this context. The case is called Fincher. And in Fincher, the property owners missed the 30-day deadline for appealing a zoning official's decision to a board of adjustment. The trial court ultimately dismissed their appeal at the court level because they didn't have subject matter jurisdiction. And the Court of Appeals reversed that jurisdictional decision and said that under Dubai, the question is not jurisdictional, but whether the Finchers established their right to go forward. So it's a merits decision. It's not a jurisdictional decision. You have the right to hear the appeal, the ability to hear the appeal, and the deadline does not impact that. The disposition is the point. Even against a party who lost, the court held that the right answer was a decision on the merits, not a dismissal for want of jurisdiction. And that's exactly what we're asking for today. It's just a merits decision. Now, like I said a while ago, the city's briefing and then the subsequent discussion really concedes that this is not jurisdictional, except that they've kind of shifted their position this morning. You'll notice the position that's in their brief is not the position that Mr. King gave to the board just a few minutes ago. The brief talks consistently about a 30-day deadline. And then he said, actually, it might be 20 days because that's what state law says. Well, their brief says 30. But the fact that they have attempted to change the deadline in the UDC to 30 days, that means it can't be jurisdictional. They can't change the jurisdiction of this board. The state does that. The state gave you your jurisdiction in Local Government Code Section 211. Your jurisdiction doesn't come from the UDC. It comes from the state, right? And so their ability or their desire to change that deadline from 20 days to 30 days, that's just one more piece of evidence that this is actually procedural and not actually jurisdictional. Now, the same statute that gives the board a deadline to decide this, not later than 60 days, nobody thinks the board loses power on day 61. It's just that the deadlines are timing rules for an orderly process, to keep the process moving.
So where did 60 days come from?
That's part of the same, that's part of the same statutory grant of authority to you. It also says you'll make a decision within 60 days, as I understand.
Okay.
And nobody thinks that you lose your power on day 61 because it's not jurisdictional. It's designed to be procedural and to keep the cases moving. So I still want to go back though, and I want to avoid arguing the merits of this because I don't think that's what we're here for today. It's very clear we're not. But there's actually quite a bit more to, can I turn this, do you want me to turn this towards you or leave it towards them since you guys have a copy?
I'm going to look here.
I'm
Okay.
using my copy.
So the first email on Mr. Kingma's timeline is somewhere in 2025, but this actually goes back considerably before that, and I assume that in your board packet you have the sort of first approval that my client got back in 2024 for data processing center. Data center is an allowed use under M1. That's what he was told in 2024. And then he bought the property, spent $600,000, and then had somebody pop up later and tell his proposed tenant that actually, no, that's not going to work. You're going to have a special use permit. So there's an assumption that underlies all this that somehow my client's in direct coordination with the tenant. That's not true. And the emails that you've seen indicate that he has some idea there's been some kind of change within the city, but he doesn't know exactly what it is. He didn't see Mr. Kingma's determination, and they haven't showed you anything that says they showed him Mr. Kingma's determination. They haven't showed you an email that says, oh, here's where we sent it to Mr. Penny. They haven't showed you an email like that from 2025. They're relying on the fact that supposedly he's coordinated with his proposed tenant. They haven't showed you any evidence he actually got that. So going back to the timeline, like I said, there's actually quite a bit of history before this 2025 decision by Mr. Kingma. And Mr. Kingma's decisions, it appears, were actually communicated primarily to the tenants. Because also in your packet, and you guys have already referenced these, so I don't want to belabor the point, but you can look at Mr. Penny's June 27, 2025 email, which is attached to Exhibit C to our brief, and you can see that he's asking there, what has happened? You know, why has the initial approval from April 4th of 2024, April the 4th of 2024, 15 months later, are we now rescinding that initial approval? And that's because he's had a conversation with his proposed tenant. But for 15 months, he operated under the assumption that it was approved because they told him that it was approved. And then we have Ms. Lopez's email telling him on July 23rd, thank you for confirming the intended future use of the properties listed below. The current zoning classification for this location is designated as M1. A data processing center is a permitted use under this zoning, and therefore a special use permit is not required. Please note that only standard building permits handled by the City of Tyler will be necessary. That is July 23rd of 2025. So they're telling you, that the deadline's run on him, even though the only communications he's ever gotten from the city say that it's all approved. Now, I think, Mr. King talked about the estoppel issue, and I don't want to belabor that point too much. We don't say that you've acquired jurisdiction by estoppel. That's not what we said at all. We say you have jurisdiction. The estoppel goes to a different issue. What we're asking is that because the filing deadline is not jurisdictional, untimeliness is a defense to our filing for them. Untimeliness is a defense for them. And a defense, untimeliness, can be stopped. They can be stopped, they can be prevented from asserting that defense. And what we're saying is not that that's where you get your jurisdiction. You have jurisdiction. They assert the timeliness as a defense, and we say you're stopped. You cannot assert that defense. And that's because of, and we've got this laid out completely in our brief. There's 5 elements to this, but essentially it comes down to this. The city has repeatedly made assertions to my client about what they can do, and every time told them they can do it. And then, when the water got hot, they changed their mind. But unfortunately, between those 2 time periods, my client has spent $1 million. So that's what estoppel is. It's a fairness doctrine. It's the idea that we shouldn't allow the city to do this, to essentially treat someone this way, and then spring up and assert the untimeliness as a defense. No, you can't do that. You gave us an explanation, told us this was approved, we spent money, and now you can't come up and say no more. That's estoppel in a very rudimentary phrasing. We got it laid out completely in our brief, but I don't want to go through that whole thing again. So we're not asking for estoppel to be some sort of remedy for us. We're saying estoppel keeps them from asserting untimeliness as a defense to us. So really, in summation, our position is really kind of twofold. Number one, and maybe 3. Number one, the deadline's not jurisdictional. Your jurisdiction comes from the statute, from Local Government Code Section 211. It does not come from the UDC. Number 2, we haven't missed a deadline, because there actually is no deadline in the UDC provision that we're being pointed to as what governs this. You seem to disagree with that, Mr. Brevard. What I'm referring to is the fact that the 10-6 refers to Division F, and Division F does not have a deadline in it for appeals. The appeal deadline that they're referring to comes from Division G, which is not mentioned anywhere in 10-6.
Is it not correct, though, that you have, in a code, you have an appeal section where that gets addressed at that point in that section?
In the UDC or in the code?
In the UDC, if you have an appeal section, I guess you're saying they're not right there together in that same.
No, I'm saying that the provision that we're dealing with here today, 10-6, refers to Division F as the appeal procedure. And there is no appeal procedure in Division F. The appeal procedure, to the extent there is one, is in a different subdivision.
Where a timeline is given.
A timeline is given, but that's not what that's a different section than what the section we're dealing with refers to. It refers to Division F. And there is no appeal deadline in that provision. We should not have to go look at other provisions when it points us to a specific provision. We don't have to go look at other provisions to find an appeal deadline that don't theoretically apply. I think the issue is the UDC needs to be corrected. But that's not my client's problem, that's the city's problem. The UDC has a bad cross-reference in it, it appears. That would be my guess.
You just stated that the state 110-6 does not refer to Division G.
Correct. It refers to subdivision, it refers to F. 10-6, A and B are what we're talking about.
Mm-hmm.
A is the authority under which Mr. Kingma makes his classification, and B is the one that talks about appeals. And it says the decision of Mr. Kingma concerning the appropriate classification may be appealed to the Zoning Board of Adjustment pursuant to Article 8, Division F. And I'm saying Division F does not have a timeline in it.
You're right, I agree. UDC Section 10-671 appeal procedures, however,
Has a
also in
timeline.
the UDC, says within 30 days after the date of the administrative decision, appeal of an administrative decision may be initiated is a little weak, by any person agreed by the administrative decision and so forth.
So there's a
So-
timeline,
So,
But that's in Division G,
right?
not Division F.
well, it's still in there.
But it's in the appeal section.
No. So what did we hear a while ago about variances? There's no deadline for variances, right? We heard that, didn't we? That's what you guys have said. That's what Mr. Keene said a while ago. The variances section is what 10-B points to. It does not point to subsection G, which has an appeal timeline. It points to the variances deadlines, which there are no deadlines for appeal in that particular provision.
Well, I think the variances are different than, because that in itself is the initial, it's not a disqualification that requires an appeal. It's mostly, well, in some instances, it is. But we have to, a lot of times, write the updates of the UDC for people to be able to enjoy the pleasure of their domicile.
Yeah, Mr. Hunt.
But it could be a typo.
I don't disagree that's a possibility. But the question is, who's responsible for that?
Well,
The
if we're
respo-
talking about a subject matter being an appeal, in the communication, and he references Division F, it could very well be a typo, because there is no subject matter regarding appeal in Division F, like you said.
Right. So a typo
Because
would be.
in itself, it is somewhat to the effect an appeal itself.
So
Does that make sense?
it does. I don't disagree with you that variances are different. I totally agree with you. But what I'm telling you is that this particular provision says that our appeals proceed under the variances appeals provision. It does not reference Division G at all. It references Division F. And so what you're saying, while I understand it could very well be a typographical error, you're asking a citizen to read the UDC and then divine from reading it that somehow, oh, there's a typographical error in here, I should maybe go look somewhere else. That's not reasonable to expect a citizen to do that, right? The citizen should be able to rely on the UDC as it's written, and if it needs to be corrected, that's a problem for the city. It's a problem for the council and the city. It's not a problem for the citizens. It shouldn't be. That's something they should correct. And maybe this will be the impetus for correcting it, but certainly my client shouldn't be charged with knowledge that there's an appeal procedure somewhere else when the provision it points to doesn't have a deadline. And they rely on that deadline. They should be allowed to rely on that.
And you're only going by the communication where it doesn't mention Division G.
Well, but that's because the UDC doesn't mention Division G. You're right. Nobody mentions Division G because it's not in the UDC, in this particular provision of the UDC. So they're asking you,
The impact of us, right now, I feel like the impact of us is only because of, what's shown in 10-590 under review authority. That we're here maybe if we get jurisdiction to hear for a zoning code interpretation.
And our argument is that you have jurisdiction, and that next week we should have a hearing on the merits.
Okay.
And we think your jurisdiction, I think in the simplest terms, comes from the local government code. That's where your jurisdiction comes from. And a deadline does not create that jurisdiction, any more than estoppel does, right? The deadline might be a reason for denying the appeal in the future, but it's not a reason for not hearing the appeal.
Would you agree, I'm sorry. First of all, let me say this. We've cut into your 45 minutes. Are you okay with us talking about this now?
What's that?
We've cut into your 45 minutes with this
No,
conversation.
I
You okay
would
with that?
assume we should talk about this right now.
Okay.
Well, you were in the middle of your closing points, and
Yeah, you had 3 points. You
was
got 2
there,
of them.
did you want to finish up before we start asking
Well,
questions?
I mean, we've danced around them all, right? So I
Right.
don't think we need to belabor them, but I'm happy to answer whatever other questions you have.
One thing that's been made clear to me over the last couple of weeks in looking at this, and whenever anybody mentions a section, I've looked that up, and I've looked up some of the case law that's been mentioned, and the Latin words also, I looked those up. And estoppel is now my favorite word. Or my least favorite. And it's been made clear to me that the local government code and the UDC and even the city's statutes can be redundant and ambiguous and unclear, and somebody's got to sort through that, and I guess that's why we're here, perhaps. I think it's certainly desirable that this not go to a court. And although that's, every time we have a meeting, it's clearly stated that that's the appeal to our decisions, is that it go to court, because that's what.
You don't have to convince me that the ambiguity creates difficulties. And I think those ambiguities should not be resolved against citizens. They ought to be resolved against the government. That's sort of the most fundamental tenet here, is that if there's an ambiguity, and we still have additional ambiguity injected this morning because Mr. Keene said he wasn't even sure the 30-day deadline applied that's in Division G, that it might actually be the 20-day deadline that's in the code, the government code. And then we have Mr. Kingma's emails, and you've seen those, telling our client that it's approved, or at least people in his staff. So that's, I think, underlies all this. Yes, there's tremendous ambiguity. We don't think that any way strips you of your jurisdiction. You can still hear the merits of the appeal. And if you decide the deadline was missed, you can deny it on that basis. But that doesn't mean that you shouldn't hear the appeal. We think you should hear it on the merits.
Would you agree or disagree that the Zoning Board of Adjustment has the authority to modify or disagree with the UDC, but not the local government code or the statutes?
I don't think that it's the board's function to modify either of those things. I think if we're thinking about the variance issue, I think you're allowed to give variances by the code, right? That's not necessarily a modification of the UDC.
You're right, because, because these are one-off decisions.
Right. So I think in that context, you're not modifying the UDC, and you're definitely allowed to do that. I don't think that really pops up here. I don't think you can modify the local government code, though.
So I've got a couple questions. Would you agree the whole reason we're here is because the special use permit was denied, was it back in July?
Not necessarily.
If that was approved, we wouldn't be here, is that correct?
We wouldn't have the same, my client might not have the same necessity. I don't think it's necessarily true that we wouldn't be here. But yes, the necessity, that created a certain amount of necessity.
So is it also your opinion that a special use permit was not needed for this project?
I think that's still my client's ongoing position, that the sub shouldn't have been
Okay.
required, and that actually comes from the city's emails too.
So, yeah, I hear you. So with that being the case, and your belief that a special use permit was not needed, why did we wait so long to file an appeal?
So I don't think we have waited, right? One thing that's happening today is, we're talking about sort of two different things. They appear to have denied this on the basis of the cryptocurrency, crypto mining kind of issue, but nobody has said yay or nay about data processing center. We have not had a single adverse determination about data processing center.
So you still believe that was, even though you were in receipt of Kyle's official determination, the second point of the data processing center was left unresolved?
It has not been resolved. That's correct.
And it's not going to be resolved today, because that's not what we're talking about. We're
Also
talking about
correct.
jurisdiction.
Jurisdiction.
Correct. I agree with both of those statements.
When did, so who received Kyle's letter?
So, I mean, he mentioned it went to the tenant. Exicor received the letter.
And when did Barrio become aware of the letter?
So it depends on whether you're talking about actually receiving the letter, which I'm not sure about. But around the same time, he got a call from the tenant
So
telling
the
him,
tenant made him aware pretty soon
I
after?
mean, obviously didn't know exactly what it had said, just there have been some changes. And so that's why he reached out with his email on, I think it's July, well, you've seen the emails.
Yeah, no, I mean, I'm just struggling why we waited until after the denial to make our appeal. If we really feel like, I don't know, it just seems like, that's what I'm struggling with, to be honest.
I understand that, and like I said, that might very well be a basis for denying the appeal on the merits, but I don't think it's a basis for saying, we're not gonna hear the appeal at all. I think that's a decision that really requires, frankly, a more fully formed record than what we're making here today.
Yeah, okay.
I think it goes to deadlines a little bit, though. When did Mr. Penny know? And-
Oh,
And was Mr. Penny the right person, and was X-Corp man the right person?
Well, I mean, since the determination is impacting Barrio, and they had his email address, you would think they would have at least let him know as well, not just the tenant.
And I do struggle the same with the timeline and that this is after other options have failed as versus a primary approach from the beginning. And then, is it your opinion then that you should be able to, on the merits, appeal our jurisdiction to hear this 5 years from, I mean, at any point in time?
So, we're not in that realm, but I understand what you're saying. I think, could somebody appeal? Yes, I think they could. And I think you could say, we're denying the appeal. And you could still do that here. Getting past today and deciding this is not a jurisdictional question doesn't mean my client wins. It means we have a full-blown hearing on the 3rd about what your decision's actually going to be. And the timeliness or untimeliness of our appeal can come into that decision as well. But we don't think it's a jurisdictional question.
You haven't made any reference to 10771.
I don't have it in front of me, but I know it's in Division G. Which is why, honestly, I haven't made any
I
reference.
guess Division A,
What's that?
Division A. It specifically pertains to zoning board of adjustment.
Okay. I don't have it in
just
front of me.
simply is given, it's just a matter of saying what our function is.
Okay.
It does mention the protocol under it for permits and so forth and such and appeals. And, you know, it refers to appeals that must be taken in 30 days also. In the UDC, it seems to be consistent. And I think that's where Kyle started with the 30, but then, you know, in further research into the statute or the law that, the state that it falls under is where the 20 came from. Is that correct?
So the 30 comes from the state, from the local government code, and the 20 comes from the local government code. The 30 comes from the UDC.
Okay, thank you.
And I'm trying to pull up the ordinance right now so I can talk about it intelligently with you. I think 10-771, if I'm not mistaken, that is in Division G.
Oh, okay, well, at the
And
top
that's-
of the page, it says Division A.
That's really my,
More or less the same thing as in G, pertaining to the zoning board of adjustment.
It's very similar, I found.
Sir?
what's
It's
that?
very similar, yeah, I found. G and F, what they said.
And our point on the construction and the statutory construction issue is simply that 10-6 refers to a particular appellate procedure. And that procedure does not contain a deadline because it's in the variances section of the UDC. And we know variances don't have deadlines. And what we're now asking, what the city is asking you to do, is to import the limitations that come from Division G and just rewrite the UDC right here today to apply that to my client. They're asking you to find that there is a deadline, when there is not a deadline.
So under the state 10 dash whatever, or whichever state stuff that is applicable here, the only mention in there is to the UDC 10,771, 10,660.
When you-
660, Division F. The only one it refers to is Division F. In the state,
The state does not refer to the UDC.
it does not.
The UDC is, we're talking about the UDC's references to other provisions in the UDC,
Okay.
and
but
it says Division F.
Okay, but you refer to under state
Yes, sir.
that it's tied to the UDC.
I do not believe that's true.
Okay,
That's not our position.
okay,
Our position is your jurisdiction comes from the local government code. That gives you the power to hear this case.
okay.
And when we get to the UDC world, we're talking about what are the procedures for this appeal? And 10-6 includes 10-6.b, which deals directly with appeals. And that says the decision of Mr. Kingma concerning the appropriate district for an unlisted use may be appealed to the Zoning Board of Adjustment pursuant to Article 8, Division F. And my point is, Division F, if you go look at it, does not contain a deadline. And that makes sense because it's actually about variances.
You know, you brought up a good point here. The original the determination letter said that the special use permit was needed because it was being classified as a digital asset, cryptocurrency, and it's an industrial process. And so that was on June 27th. And then on, I guess sometime after that, in between June 27th, July 23rd, it was recategorized, or you redefined it as a data processing facility. And then the city responded with, well, data processing facility is a permitted use under this zoning, and therefore a special use permit is not required. So after receiving that email, and seeing that special use permit was not required, then was it your assumption you were in the clear? And if so, why? It looks like you guys attempted to get that in writing but never did it. It just seems to me the usual process there would be to get it in writing officially before moving forward. It just seems like we left it there in limbo and no one seemed to follow up with it.
I think there's 2 points I would make. Number one, we'd love to get that in writing, and you can see my client's emails are a consistent attempt to get that and can't get it. Can't get the city to say what we can and can't do. And if we knew that right now, we wouldn't be holding a piece of property that we can't market because we don't know what we can do on it, right? But going back to your first issue, we didn't change anything. Data processing has always been part of the use of this thing.
But it appeared that you reclassified it, or you used different language. Basically, the city denied it under Bitcoining, and so then you came back and said, well, it's actually data, you know, the definition of the facility was changed at that point, and then it was left pending.
Can I let Mr. Penny speak to it?
Yeah.
Because he obviously is in the weeds on this way more than me.
Yeah, just a couple of points. You guys were,
Name and address, please.
sorry about that. It's Ivan Penny. My address is 1129 East 6.5 Street in Houston, Texas. Thank you guys for letting me speak. I just wanted to bring up 2 points. We were on a discussion around, hey, why are you guys bringing up the protest now? So if you look at that timeline, we didn't really receive actual notification from this until April 13th. When those two tracks, that's when we got our hands on the actual email of the determination. And what we're trying to do, we're trying to work with the city and move forward the best way we can. So there's 2 ways we can go there. It's hey, we can fight this decision that occurred that we didn't know about months before, or we can apply for the special use permit process. And we deliberated, and we thought the best way to do that would be to apply for the special use permit under protest, remaining stating the fact that we did not believe that a special use permit is required. And we actually stated that during the meeting with our submission as well. So that, I just wanted to hit on that point. And then just to characterize the emails, you could see I got a phone call from our tenant at the time saying, hey, there's a special use permit that's required. I really didn't understand the process, and you can see in my email communication, I was way off the mark. And I'm asking the city to provide some sort of explanation. Hey, is this special use, this is data processing, we got approval before, what happened? They didn't respond. I followed up again, they've asked, hey, what is your use? Can you describe it to us again? And in that email, I even mentioned, AI, high performance computing, and also Bitcoin mining, which is tenant is doing. And then I received a response from the city that yes, and this is after the determination. I'm sorry, I'm nervous. I'm shaking a little. This was after Mr. Kima's determination that hey, they have my listed use. That hey, a special use permit is not required. Please move ahead, normal permitting. And it wasn't until months and months later where we were attempting to get permits that we started getting problems and had to go into the city and sit face to face and actually get these handouts of what happened with the property.
So then it was your assumption after receiving that follow-up
You
email
have 3 minutes remaining.
that a special use permit was not required, then you were just assuming, hey, we don't need a special use permit, we're rolling.
Correct.
And then it came back up when you started filing for permits.
Correct.
Okay, got it.
Yep.
Makes sense.
Was it clearly defined what was to be done under the data processing label when you were told that with an SUP, you could do what you want to do at the M1 zone?
So I'll point you to, you want to know how it clearly was defined? Mr. Penny's email is July 23rd, 2025 at 11:24. And that is in response to a series of emails right before that start on June 27th, where he's asking for clarification, what can I do? And he asks, is the prior approval being rescinded? No response. So on July 22nd, about a month later, he follows up. And finally got a response at that point from Ms. Lopez, and she said, can you tell me detailed information regarding your intended use? And so Mr. Penny sent an email and said the facility will house thousands of computers supporting AI and high-end performance computing operations. We anticipate maintaining a staff of 3 to 5 for continuous 24/7 operation. Notably, the data center will operate as a flexible load, suspending operations during ERCOT mandated power conservation periods. And then he goes on to describe the cooling. I mean, it's a 3-paragraph email that I don't want to read to you.
I've read it, yeah, I've slept.
And then she says, thank you for confirming the intended future use. The current zoning classification for this location is
1
designated as
minute
M1.
remaining.
A data processing center is permitted use under this zoning, and therefore a special use permit is not required. Please note that only standard building permits handled by the City of Tyler's permit department will be necessary.
Right, okay, so still it's a vague term, data processing. That's not even used in defining M1 zoning
And we're not gonna,
usage.
and we're not gonna define it today.
No,
Correct.
we're not.
It's not the
Okay,
issue.
so I just wanted to get that out of the way. And because I know that the timing thing has to do with just the initial thing, and that's what we're doing. However, one can't help but wanna put it all together and make an prudent decision. Because to me, I feel like y'all are, this is your next course of action, essentially.
Well, there's no question that,
Unless you just wanted to sue everybody that's got a rose on their palate.
well, I don't think that's the
Lapel.
plan.
May we,
No.
lapel. So, that's it.
My time is up.
Your time is up. I'm going to extend the time because we did discuss this and it was not just presentation. And I think Jason has one more
we
question.
not do that?
Is that not all right?
You'll have time to ask on rebuttal. They still have additional 15 minutes to
All right.
come back up.
Hold that thought. Thank you, sir.
Thank you.
thank you.
Anybody want to take a break? Need to take a break?
I'm good.
Okay, we'll keep going then. Thank you, sir. We will now move to rebuttal. Each side has 15 minutes. City, you may begin your rebuttal. 15 minutes starting now.
Hello again. Again, Kyle Kingma, Planning Director for the city. Just wanted to mention, I'm just gonna provide some initial responses to what we just heard from the appellant, and then Steve Keen will take the balance of the time. And so, the first thing I wanted to mention was that the applicant and the owner had the answer to the question that was being asked already. That through the procedure with Exicor and again with the owner's assistance on that, in those communications, they identified the proposed use during that process, which is what I, as the planning director, determined. I utilized that information that was provided in its totality to make that determination. I was including all encompassing what they mentioned. So I just have kind of a summary here, or this is really the email that was provided to me in terms of the proposal. And so I mentioned it earlier that the proposed use, again, was a Bitcoin mining operation, paraphrasing a little bit, that houses specialized computing equipment to perform continuous high-intensity data processing tasks similar to traditional data centers. And so there was an equation of everything that they've mentioned plus the Bitcoin mining. And that is, and their conclusion was that the Bitcoin mining facilities are data centers that should fall within the data processing services. My response to that is, in response to all of that information, was that no, that this is actually a different use than what is allowed under the current zoning, and that it would require a special use permit. So when the response is that that there is something, when they asked maybe a different, the question on July, where they had a response to proposed use in July of 2025, the city would just respond to that they already had the answer to the question that they asked, and it was provided on June 27th by myself. I also want to mention the questions about the, and I also, just to follow up on what the appeal language was submitted by the appellant. It was, as you see here, they are specifically, yes, that's what specifically they mentioned that they are appealing that decision on that date. So they are appealing the decision on June 25th, or June 27th, 2025. That is what they filed. Go back to, and so there was discussion about a special use permit, and when that was filed, And so this is the acknowledgement, like I mentioned, that the communication with the tenant and in coordination with Barrio, this is the information they've supplied to the tenant to support that discussion. So there is that.
Who is David Gibson?
Exicor is the tenant.
Both of these guys are Exicor?
I'm sorry, what was the question?
Mac Morelli, it says exicor.com, but
Yes.
David Gibson, is he Exicor also?
Mac Morelli is the tenant. David Gibson is the chief building official.
Oh,
So the city
sorry
staff.
about that, I should have known that.
Kyle, what's up with the 30 days and now 20 days? And, I mean, because everything we have here says 30, and then today, in our presentation, it said 20.
The UDC says it's 30 days. State law says 20 days, so neither party can change that 20-day deadline. UDC needs to be updated, but this is governed by state law. It's 20 days.
A question to
Yes, sir.
to that point very quickly, just because this has been brought up. Section 10-6B, an appeal with no date on it for
Yes.
Division F versus Division D, 10.771, I think in my memory, I've got to find it, but in 211, to jump under the code, and referenced by everyone with agreement about the local government code, chapter 211-010, appreciate you helping clarify these things when that code says, and I'm not going to read the full paragraph for time, but an appeal to the board, decision made by administrative official, I'm excerpting out, that is not related and basically is being challenged. It goes on in A-1, item number 2, subpoint B, the appeal must be filed not later than the 20th day after the date the decision is made. Again, I'm skipping over for time.
Yes, sir.
So help me understand 211 of the government code, .010, and section 10-6B that has no date on it in the UDC code, and how we reconcile that.
Yes. There's more than one city code section which was cited in my brief related to zoning board of adjustment. Your authority is statutory. It comes from Texas Local Government Code, Chapter 211. 211.009 mentions the specific authority on considering an administrative appeal. That's why we're here today. This is an administrative appeal of the planning directors. The city's position is they didn't meet the state law deadline for filing that appeal, so you have no jurisdiction to hear. That's where we disagree again with Barrio. If section 211.010B, the 20th deadline, is not jurisdictional, then why is it there? Why is there a requirement to file it within 20 days? It has to be read in conjunction with 211.009, your authority to conduct administrative appeal. 10-6B was cited from the UDC, but that only applies to variances. It doesn't apply to this particular matter. In any event, 10-771 and 10-671 of the UDC relate specifically to administrative appeals. Those are the ones where we have the 30-day reference, which should not be 30 days, it should be 20 days.
Okay. And on the 10-6B, in that context, you're arguing that doesn't apply here, or
At all.
Okay.
It's a relic, that's a provision that needs to be updated, but your authority as a board comes from the state law. Doesn't matter what the city code says.
Section 211.090 and .010.
Yes, sir.
So state law, in your opinion, supersedes anything the UDC is going to have in there that may be outdated or anything like that?
Yes, sir. And I would add that the city has not changed its position. Kyle's interpretation has been consistent throughout. It's been consistent since June 27th, 2025.
Well, and I would like to hear your response to that. You know, obviously Kyle sent a determination letter, and then it appears the city said, well, this doesn't need it. And then there was allegedly 2 or 3 follow-ups looking for clarification, and there was no response, and now the applicant's operating off the assumption that since the last communication they received was that a special use permit wasn't needed, we're rolling until April under the assumption that wasn't needed, because that was the last time we heard from you, despite repeated follow-ups.
Yes, in that regard, Kyle is the planning director. He makes the interpretation. So at the time, you do have emails that appear to be conflicting. So to rely on 1 or 2 emails right when they're conflicting, and you'll see it cited in my brief, the applicant could have sought a zoning verification letter from the city. It did not, and that's usually what is done. You want something official. If there are conflicting provisions, that should have been the step. But also, I would add, and this was brought up in the applicant's presentation, the 2 SUP filings with the Planning and Zoning Commission. In order to do that, a special use permit, only the owner or the owner's agent can file for a special use permit. Now, they may not have agreed that they needed a special use permit, but that's not the issue. The issue is they were aware that the planning director's interpretation required a special use permit. And if they disagreed with that, it should have been appealed. Should have been appealed as early as June 27th. Certainly should have been appealed in April. If not April, certainly should have been appealed in May. All of those time periods have passed. Again, I get back to it's 20 days under the state law, and we have 384 before they file.
Yeah, I hear you on that. But, so is it your opinion then, you know, Kyle says one thing, it appears another person from the staff says something else, that as a representative for the city of Tyler, if they say something, they should not take that at face value. They should go to the boss and get his confirmation. Is that what you're saying?
Well, I would argue that they should be able to rely on communications, but Kyle is the planning director, which has been indicated. And even after Kyle had issued his interpretation, we still have communications going not to him directly, but to the planning department in general. When he's the department leader, he's the one that issued the opinion, but they're talking with other planners rather than the person that's already issued the interpretation. So that would be my argument. Yes, they should be able to rely on everyone, but they were aware of Kyle's interpretation, and the 20-day deadline is tied to the date of his interpretation and when they had knowledge of it. Kyle's already indicated they had knowledge of it the same day.
So
Barrio had knowledge June 27th, 2025.
you have some-
So, I mean, just looking at the timeline then, Kyle's determination was on June 27th, and on July 23rd is when they got the conflicting,
Yes, sir.
and so going by the state law of 20 days, that would be past the 20-day window.
2 minutes
anyway.
remaining.
Yes, in that regard, you have differing issues, but his is the interpretation that's being appealed today.
Okay, yeah, okay.
Not the others. And one brief comment, I wanted to reiterate this, and Kyle mentioned this a few minutes ago. Their appeal filed July 16th, 2026. I'm just going to read it. Barrio takes issue with the decision of the City of Tyler's Planning Department. Specifically, Barrio seeks to appeal the Planning Director's interpretation of June 27th, 2025, made under section, and then that's where there's the discussions we've had on 10-6. That cryptocurrency mining is an unlisted industrial use permitted in M1 only with a special use permit, SUP. And then that was included as an exhibit in the city's brief. So the 20 days ran to appeal to this board if they disagree with Kyle's interpretation. 20 days ran from the date they became aware of his interpretation, not filing an appeal over a year later. I would also add this, since I've got 30 seconds. Even if there had not been a state law deadline, which is how the code used to read before 2019, and I say the code, the local government code, the state law, it used to be you had to file an appeal for an administrative decision within a reasonable time. The legislature added that 20-day deadline in 2019, so there's a purpose for that. Under the common law, filing an appeal a year after the interpretation would be unreasonable. So that would be my last argument.
Thank you, sir.
Thank you.
Time is up. We will now hear from Barry O. You may begin your rebuttal, 15 minutes starting now.
I don't want to belabor the points we made before. I'll just say, if you look at the city's brief that we're here today, the number 30 is in that brief 29 times. So and the first point is the sole issue before the Zoning Board of Adjustment at this public hearing is this. Did Barrio file its appeal challenging the planning director's interpretation within the 30-day statutory deadline for the Zoning Board of Adjustment to obtain jurisdiction over this appeal? The 20-day, I'll tell you where it comes from. It comes from the fact that we said that deadline's not jurisdictional. And the fact that they've changed the deadline from 20 to 30 in the UDC supports our position that it's not jurisdictional, because they can't change your jurisdiction. They can change the processes and the deadlines, but they can't change the jurisdiction. But the ridiculousness of what we're talking about here is that the UDC says 30 days, local government code says 20 days, their brief says 30 days, and now, like less than 96 hours after they filed their brief, they're now telling you it's 20 days. It's got to be 20 days because they can't change it, and that the UDC needs to be updated. Again, that is not my client's responsibility. My client is not responsible for updating the City of Tyler's ordinances. It's responsible for attempting to follow them. And they can't even figure out what they are. They're asking my client to follow an ordinance. They can't tell you what it is. They can't tell you what the deadline is for following the ordinance. They don't know. They said 72 hours ago, and now they're telling you 20. But they're asking my client to be able to divine whatever these deadlines supposedly are. And our position is still that there is no deadline in Division F. If they want to change it, they can change it. But that's on them to change it. It's not on my client to go, you know what, this says Division F, but I bet they really meant Division G, so I'm going to go look at Division G and follow Division G. That's not the way this works. Due process requires that you at least give my client notice of the rule that's being applied to. And they haven't done that. The other thing I would note, they say that my client knew about Mr. Kingma's decision when Exicor got that decision. And they gave you an email that had Exicor employees on it. It does not have my client on it, even though they have his email address, because he is the one who filed some initial paperwork in 2024. They've got his email address. So they have the ability to respond to emails. They did it. But my client asked for clarification 3 times and got nothing. And the only time he did get something, it said you can do what you're asking to do. So what we're talking about is asking, it's unreasonable to ask a citizen to be able to do what they're saying he should be able to do. Oh, we should have changed the UDC. I mean, we can all agree on that, but it ain't my client's responsibility to change it. That's their responsibility to change it. And my client has to live with what it says, not what they wish it says or what it's supposed to say. He has no way to know what it's supposed to say. So the decision today to fall back on the 20-day deadline is really self-serving, and it's designed to make you think that this is a jurisdictional question when it's not. It's a procedural question about a deadline. And you can use, if you think my client missed the deadline, you can use that for denying their appeal on the merits. But it should not be a reason for us not to get there. Mr. Trimble, you had a question earlier that we didn't have time to get to. I wanted to make sure I left a little bit of time to answer that for you.
Well, I think it's being addressed, but I really want to get your perspective on, again, what I said in the prior group on the Local Government Code, Chapter 211. If that is the bottom line for us, it has a 20-day deadline, and we've established notification was given. maybe not ideally, but there was an awareness, if not in 2025 in June, there was an awareness in April and May, which is well beyond the 20 days today, or for the appeal that's been referenced, well beyond the 20-day deadline. And so how do you respond to that? If you're asking us to throw it out or to look at it as having jurisdiction when the government code says 20 days, which it would establish that we would not because it did not meet the deadline.
Fair enough. So I believe 211 gives you jurisdiction. I don't think that deadline in there is required for jurisdiction. There are hundreds of deadlines all throughout the codes of the state that are not jurisdictional. We have deadlines in court that are not jurisdictional. We have deadlines to do certain things, and if we don't do those things, it doesn't strip the court of its right to decide a case. So there are two cases that we cite in our brief. It's Dubai and Fincher. And Dubai is the case that stands for the proposition that deadlines like this are not jurisdictional. And Fincher is the one that says explicitly it applies when it comes to a zoning board of adjustment decision. So those two cases, I think, point to the notion that this is not a jurisdictional question. It's a process question. It's designed to make sure that cases keep moving, but it is not a question about whether this board can hear this case. 211 decides that you're the perfect people to hear these kinds of cases, and you can hear this case on that basis. And I don't think the 20-day deadline inside 211 is jurisdictional and strips you of the ability to hear the case, even if you decide my client missed the deadline. Any other questions I can answer?
Is that the end of your rebuttal?
It is.
Okay, I have a question. I'll let you respond to this. We got 9 minutes. And that'll be it for me, I think. There's a principle, apparently, I've learned, known as detrimental reliance estoppel equity. Does that apply here, do you think?
So we've mentioned estoppel in our brief. And I mentioned it briefly in my initial discussion with you. They say that we're trying to do an end run around the fact that you don't have jurisdiction and create jurisdiction with this estoppel argument. We're not saying that. We're saying that 211 gives you jurisdiction. They have a defense that says we were not timely. And we're saying that estoppel prevents them from asserting that defense. It's a three-layered process. We're not saying that estoppel is where you got your jurisdiction. We're saying that on the merits, that untimeliness should be stopped. They should be stopped from asserting that because of all the chaos we have in these emails and the fact that we've been led to believe that what we're doing is appropriate and all those kinds of things. I still don't think that really comes to the jurisdictional question at all. I think the jurisdictional question just goes to whether you can hear that, and I think the estoppel would ultimately be a merits question.
Thank you.
Thank you.
Thank you.
Thank you.
All right. Now we're going to go to the public speaking part of this, and there's a lot of you out there, but I only have one person signed up here to speak against it. I'm going to ask here in just a moment if anyone wants to speak for this, and if you do, just, I guess, raise your hand and come up to the front here and form a line, and we'll do that. You're going to get 3 minutes, and that's it. And please be aware that we are here today not to talk about the pros and cons of data mining in any way. All we're talking about today is the application for this variance and whether or not we're able to even consider that. We're not even considering it. We're just talking about, can we talk about it? So, if you want to talk about pros and cons of data mining, you got 3 minutes, but we're not going to consider it today. Is there anyone here to speak for or against this? I'm going to change that a little bit. Is there anyone here to speak for this item? Okay. I have one person signed up to speak against it, Emily Pinal. You want to come forward and state your name and address, please? And then I'll ask again in a moment if anybody else wants to speak against it.
Good morning. My name is Emily Pinal, 1020 West 10th Street, Tyler, Texas 75701. So as someone who also serves on a city-appointed board, especially one leading on the city beautification efforts, I too understand the importance of keeping our community's trust at the forefront. A Bitcoin data center would be a disservice to the beautification efforts the city has invested in, but most importantly, a deep harm to the communities who would suffer from the short and long-term effects that would follow. During the Planning and Zoning Committee, we spent over 3 hours of listening to the community input. That consisted from neighbors, neighboring homes, businesses. So truly today, I just come to ground us and to encourage you all not to revisit, not only to revisit that recording, should you consider this appeal, but also to recommend the continuation of conversations in regards to a moratorium for all type of data centers for the city of Tyler, Texas. Thank you.
Thank you. Is anyone else here to speak against this item? Please come up, ma'am.
Thank you. I'm Nancy Nichols. My address is 11650 County Road 4215, Tyler, Texas. I am here to thank you for allowing this opportunity for our citizens to follow the process. However, it would be wonderful to open it up for citizens to hear again about data centers and what's going on, because since the June meeting, there has been even more evidence coming out talking about how detrimental, how very dangerous the existing kinds of data centers that are being put across Texas, how very dangerous they are. They are dangerous not only for human beings in terms of hearing, in terms of our entire bodies, what's going on, to live in close proximity of data centers, but also for our livestock. And we know that that's very important for our economy. We live in rural Texas. We know that we need and we rely on rural Texas, rely on agriculture. The third thing has to do with, and I just lost it. But I do want to thank you, and I do want to also emphasize that listening in the audience, and I'm listening, I'm looking back on the 2025 information about Barrio, about Vulcan. Well, who's who and when did they become who they are, and whose hand is actually in the honeypot about this? Because when it comes down, it's all about money. And it's really not about jobs for people. It's really not about citizens' health. It's really not about our economy. And I appreciate that you're taking all of these things in, oh, I remember what it was, that we have even more data about these closed-looped data centers, or Bitcoins, or data centers, or Bitcoins, because we were hearing that being interchangeably used, but yet still designated differently according to however the terminology fit that particular sentence structure at the time for Barrio or Vulcan or whomever was speaking at the time. Going back to that, there's no such thing as a closed-loop center. We know that now. Even more data is coming out about that, but you guys know that. Y'all have been sitting up there. You know what radiators are. You know you have to flush a radiator. That's just the way it goes. That there's no such thing as a closed-loop system. That same thing is true not only with data centers, but also that kind of data center that comes under the label of Bitcoin. Thank you very much.
Thank you. Thank you. Anyone else want to speak today? I have to see a hand up. Come up to the front, please.
Hi, my name is Cameron Ortiz. My address is 415 Landon Street, White House, and 5791. I don't want to get too into against AI data centers or like the harms that it pose. The thing that I feel probably hasn't been mentioned, or it has been mentioned quite a bit, but the fact that, and my heart goes out to you, and I know that it's so hard to invest into something and to have a time where you don't know what's happening and you don't get a clear answer. That's very difficult, and we should have very good processes. But with what an AI data center is, it has a very specific operant in kind of close to like what factories are, and it harms the community so much so that a special use permit should probably be required or heavily considered. Sorry, excuse me. I didn't actually plan on speaking today, so I was a little caught off guard. But I do think it's important that we look at what it does. What is it bringing to our community? It brings to our community profit for somebody. It doesn't invoke togetherness. It doesn't invoke a betterment for each other, for one another. It does open some jobs, but it opens jobs at the cost of our environment, at the cost of our safety, at the cost of trusting one another, and at the cost of what it means and what our values are in this city. And our city isn't just profit. Our city isn't just making money or fueling what AI does. Our city is about togetherness. It is about reaching out for each other. It's about making sure that we have the means to support each other in rural East Texas. And again, once again, my heart goes out to you. But it is really important that we consider how dangerous, how much it doesn't offer to us. And when we are looking at this, to push that it goes through the requirements of a special facility. Are there going to be reimbursements for what happens when inevitably it starts affecting our water? It consumes a lot of water that we drink, our drinking water. What's going to happen? Who's going to pay for that? Are we going to be able to make claims as citizens who live here? And right now, it doesn't seem like we're actually getting a choice in whether or not this data center is being made, depending on how the hearing goes. What happens to us after that?
30 seconds.
Thank you. And who are we going to have pay for our medical bills, our hearing loss, for what's going to go on? I also want to mention one more thing. The location there is kind of in older Tyler, and a lot of those have a bunch of underwaterways that are being redeveloped, and it's going to cause an even more extreme risk for our water sources. Thank you very much.
Thank you. Thank you. Last call for speakers. All right. Anybody else? So there's two more? Okay. Then we're going to call it.
Hello, my name is Amanda Mosley. I live at 1502 West Lawler, which is about 2 or 3 blocks from where they're proposing this. I'm not going to go into the whole horrors and annoyingness of data centers. We already know that. It's all on the news. We already see that. My one question is for the company. When you found out that you needed a special permit, why didn't you appeal then? Why did you wait to go through the whole process of the special permit and the whole thing? Why didn't you just apply and appeal right then? They just showed where they could have appealed within 30 days if they felt that if they felt that the special permit was questionable instead of the M1. Why did you go through the whole process and then decide, well, you know what? We should not have even gotten the special permit distinction in the first place. We should have stuck with the M1. So that's my question. Why did we go through the whole process with the special permit if you felt you didn't deserve the special permit to begin with? That would just be my question. Thank you.
Thank you. One more, sir.
How are you guys? My name is Reese Shaw. I live at 155 Chaparral Run in Tyler, Texas. This is my first time at this hearing, but I do represent and build data centers across the state. I can say that I've spent a number of time working with different cities and different co-op electric companies throughout the state. I can imagine that it's probably difficult to work on building a data center when you're getting different information from different folks across the state that you're trying to work with. I can also imagine that it's probably pretty difficult to build a data center when the information is flowing to your tenant rather than the developer or the property owner of the project. When you build a data center, your tenant can change at any given time. I'm 100% for data centers. I do think they need to be built responsibly, and there are ways to do that. Closed loop systems are becoming more and more effective. And there is science behind the facts that there are ways to lower the overall acoustics of a data center. That's all I've got to say. Thank you, guys.
Thank you.
Are you a party to this process at all?
No, sir.
Okay, thank you. Thank you. Are there any more questions by the board? Hearing none, that concludes, yes, sir?
No.
Thank you. That concludes our hearing on this item. The next meeting is scheduled for September the 3rd, 2026, at which the board will conduct a vote on jurisdiction at this time. It is only a vote on jurisdiction, not a vote on a variance at all.
Motion?
Do I have a motion to adjourn?
Sorry, to clarify, September 3rd is the day we'll cast the vote.
Say, I'm sorry, couldn't,
September 3rd is the day we'll cast the vote.
we will vote
Yes.
on jurisdiction, not on the variance.
September 3rd.
Is that right, sir? Mr. King, is that right? Thank you.
I believe,
That'd be the
once
only
we
item.
do that, we hear something else next week.
So the process will be, on September the 3rd, you guys will vote on this matter that we're talking about today, which is whether jurisdiction rests with this board. If you find that jurisdiction does not rest with this board, it goes somewhere else. If you find that jurisdiction does rest with this board, then we will go into subject matter and you will hear this matter
In that same meeting?
in that same meeting.
Okay.
And
there's
then
a
vote on
third-
it at the third meeting.
Yes.
Okay,
Okay.
thank you. Thank you. Clarity prevails. All right. Do I have a motion to adjourn?
I make a motion.
All right. A motion and a second. Any opposed? Well, sorry. All in favor, say aye.
Aye.
Any opposed? Meeting is adjourned. Thank you.
Thank y'all.